Good afternoon. As David mentioned, my name is Diane Wehrman, and my discussion is going to focus on the minerals underlying the bed of the Missouri River within the Fort Berthold Reservation. To provide a very brief background of land ownership within reservations, during the late 1800s to the early 1900s, under the federal policy of allotment, lands in the reservation were split up into individual parcels of 40, 80, 160, or 320 acre tracts and allotted to individual members. These are individual trust lands. The United States holds title to these lands for the benefit of individuals. Title to these tracts will descend to their heirs or devisees by will or intestacy through BIA, the Bureau of Indian Affairs Probate Administration. The three affiliated tribes are also the owners of mineral interests and other surface interests that are lands held in trust by the United States for their benefit. The lands that are not trust are fee. Fee lands can be owned by anyone, non-Indians, Indians, or the tribes. At one time, some of these lands may have been trust, and they have since passed out of that trust status, but it's also possible that they were never allotted and that they were part of the Homestead Acts. The allotment policy was abandoned in the 1920s, and it's generally acknowledged as a complete failure. It has created several ownership issues where you now have 160 acres that could be owned by several hundreds of people, and it makes it really hard to make a good economic use of those lands. It's also created several jurisdictional issues because you have a checkerboard of ownership where you have a fee tract next to a trust tract, and who is in charge and who's responsible is a difficult question to answer. Throughout the presentation, I'm going to refer to the three affiliated tribes as either the tribes or the MHA Nation. MHA is the Mandan, Hidatsa, and the Arikara. I'm mainly going to focus on the tribal trust interests, oil and gas, which are riparian to the Missouri River, and then also some of the questions that we have to ask about ownership of the minerals underlying the river within the reservation. This is a map courtesy of the North Dakota Studies program at the State Historical Society. It represents the boundaries of the reservation in 1910, and it's also going to give you a pretty good sense of where the river flowed and about the communities within the reservation at that time. The original description of the three affiliated tribes' territory in 1851 included 12 million acres. It stretched into South Dakota, Montana, and Wyoming. Through executive orders and statutes, including the allotment policies and homestead, between the 1870s and 1910, the size of the reservation was reduced dramatically. Today, it occupies approximately 1 million acres in Mercer, Montreal, McKenzie, Dunn, and McLean counties. It's important to think about it that not all of the tracts within the reservation are owned in trust. There are vast tracts which are owned in fee, and it's also important to think about it as a severed estate. So you could have a fee surface tract and a trust mineral tract, and vice versa. So for the Army Corps of Engineers to acquire lands that were necessary for the Garrison Dam, they had one of two methods for fee lands. They could either obtain deeds from the owners that may or may not have included a reservation of mineral interests, or they could initiate a private condemnation suit. But for lands within the Fort Berthold Reservation, which the United States owned in trust for the benefit of the tribes or for the benefit of individuals, the lands for the Garrison Dam were taken by federal law. Public Law 81-437. The Act describes the exterior boundaries of the takings area, totaling 174,000 acres. Of that, the Act identified 20,000 acres that were not included in the taking, likely because these were lands that were already owned outside of trust status. The Act also describes the relocation of the communities and the compensation that had been calculated for the taking of all of the land. According to one report prepared by the Assistant Regional Director of the BIA in 1948, there were 357 homes, occupied homes, within the reservation boundaries. 289 of those homes lied within the takings area. 80% of families living within the reservation had to be relocated. Here's another map, also courtesy of the North Dakota Studies program, just to give you a little bit of a sense of the impact that the flooding of the Garrison Dam had on the reservation. And you can also see in this map how segmented the reservation communities are from each other, and then again the communities that had to be relocated. In 1984, Congress passed the Fort Berthold Reservation Mineral Restoration Act. And what it did, lands that had been taken for the Garrison Dam, that lied within the reservation boundaries were conveyed from the United States to the United States in trust for the tribes. And while they refer to it as restoration, that's a little bit misleading. Some of these tracts may have been held in trust for the tribes. They may also have been held in trust for the benefit of individuals, but they could have also been fee tracts. And as I've noted, there were some lands accepted from the conveyance and accepted from this act, and they were primarily in the north and eastern portions of the reservation. The Restoration Act requires that the development of oil and gas of the lands subject to this act will be subject to the regulations imposed by the Secretary of the Army. In this map, available through the North Dakota Industrial Commission Department of Mineral Resources Oil and Gas Division's website, you can see the green outline tracts represent tracts that are either partially or entirely owned by the United States in trust for the benefit of the tribes or for the benefit of individuals. And you can also see the green oil derricks that are representations of the actual drilling rigs that are operating within the reservation. Later maps are going to be zoomed in a little bit more so you get a better sense of how much activity is occurring within the reservation. Before I get too involved in the riverbed within the reservation boundaries, I'm going to take just a little detour to tell you about another federal law impacting the leasing of allotted mineral interests within the Fort Berthold Reservation. Under the Mineral Leasing Act, 100% of individual allottees had to consent to a lease in order for the BIA to approve the lease and for development to occur, with the thought that only one person or perhaps one family was the owner of that 40, 80, or 160 acre tract. However, we have the issue of fractionation, where at this point there are few tracts that are owned by a single person, and my example indicates what happens through the generation. In my scenario, we have an original allottee who owned a 100% interest, which passed to 3 kids. I've left it off, but it would take 2 of 3 kids to achieve majority consent and 3 of 3 to achieve 100%. Then 2 of those 3 kids have multiple children of their own, and now you're looking at 1/9 and 1/12 interests. In the 3rd generation, you've split that 1/12 into 3 1/36 pieces, and by the 4th generation, that you can't even read on that screen, you have 1 144th, or 0.694%. In an 80 acre tract, 0.694% is the equivalent of 0.556 acres. In response to the problem of obtaining 100% consent to develop lands, Congress passed Public Law 108-188, the Fort Berthold Mineral Leasing Act. It provides that the BIA can approve a lease once owners representing a majority of the mineral interests have consented to lease. As indicated by the total acceptance listed on the bottom of the slide, you don't have to achieve a majority of the owners, only a majority of the interests. In this map, we're zoomed in a little bit more, and you can see that the black lines that are the representatives of the horizontal legs of the wells. As you can tell, there is a great deal of activity occurring on sections that include portions of the Missouri River. This is the same approximate view, but without the blue map overlay. The sliver between the green on both sides represents the location of the river when the original GLO survey was completed, or at about the same time that the lands were allotted. This does not represent where the river was in 1953, about the time that the Garrison Dam was closed, and it certainly does not reflect where the river flows today. But between the GLO survey and the approximation of the river available through the Oil and Gas Division's website, it's obvious that the river has changed dramatically. With all of that background information in mind, we have to ask a few questions. Who owns the Missouri River within the Fort Berthold Reservation? Is it the state or the 3 affiliated tribes? If the state owns the riverbed, the tribes and the United States in trust for the tribes, along with the state, will have to determine the issue of location and acreage. If the tribes own the riverbed, then the United States in trust for the tribe and the tribes will have to determine the location and acreage. There are various ownership theories of why the 3 affiliated tribes is the superior owner of lands within the reservation, but some of those theories suggest that they would own those minerals free of any trust restrictions. Then we ask, where is the river? Is it the bed of the Missouri River prior to the flooding of the area? Is it the present river, which is also referred to as Lake Sakakawea? And then, How do you determine the acreage? As it's been mentioned, survey professionals will come to different conclusions based on the ground surveys where they can really analyze vegetation, trees, and then all of the other factors that I should probably learn a little bit more about before I try to talk. And I will say though, when you look at the 1952 image that David brought up earlier, that is the best aerial photograph of the time before the lands were flooded. So if survey professionals can come up with different on-the-ground survey results, imagine how many different interpretations you could have when you're looking at a black and white photograph from 1952. So this map on the left indicates, again, the approximate river location, and this time I've left on the Fort Berthold mineral tracts layer through the oil and gas maps website. And then on the right, you have the same approximate view, but this time with the satellite image overlay. So on the image on the left, you can start to see the difference between the shading. The individual truss tracks are slightly lighter, and then the tribal truss tracks are going to be the darker ones, and those ones occur mainly along the river, and that is due in part to the Restoration Act. So I'm now going to discuss a few federal cases as the same relate to tribal or federal claims to water bodies with the effect of defeating state title to said water body. But before I start talking about a specific case, there are two competing presumptions that are involved in these issues. The first, the case law establishes a strong presumption that the United States retained title to the bed of navigable waters for the benefit of future states, so that upon the state's admission to the Union, the state would acquire the riverbed, subject only to the U.S. navigability easement for commerce. Also, in some of the cases, or in some events in the dissenting opinions, they discuss what is often referred to as the Indian Canon of construction. And to put that very simply, ambiguities in treaties are to be resolved in favor of the tribe, as that tribe would have understood the term. As of August of 2012, there are 566 federally recognized tribes in 48 contiguous states plus Alaska. So you have to think that every tribe has a unique history, both its historic and cultural development, but also its relationship and interaction with the federal government. In several instances, these cases involving a tribe's claim to river focus on that tribe's unique characteristics in determining whether the tribe was the owner of that navigable water. The general considerations discussed in these cases may or may not be important in determining the ownership of the minerals underlying the Missouri within the Fort Berthold Reservation, but they do represent a broad overview of what has been considered in the past. One factor that's been discussed, the first is in Idaho v. United States, where the United States brought suit to quiet title to the portion of Lake Coeur d'Alene in northern Idaho in the Coeur d'Alene tribe. The earliest description of the reservation did not include any water, but the tribes had petitioned the federal government, and in 1873, the boundaries of the reservation were amended to describe nearly all of Lake Coeur d'Alene and a portion of the St. Joe River. The amended treaties, were never ratified. By 1889, the United States was negotiating with the Coeur d'Alene tribe for the northern portion of the reservation, including 2/3 of the lake. The court points out that while the treaties identifying the amended reservation were never ratified, the only party negotiated with and compensated for these northern lands and for the 2/3 of the lake was the Coeur d'Alene tribe. Another defining consideration in this case was the description of the lake. So the normal practice of using meander lines to describe boundaries around water bodies was not used in the description of the Coeur d'Alene reservation. Rather, they drew a straight line across the lake. Ultimately, the U.S. in trust for the tribe is determined to own 1/3 of Lake Coeur d'Alene and the portion of the St. Joe River within the reservation boundaries. Specifically, the treaties did not describe the river, and the river was not an important part of the Crow tribe's way of life, implying that ownership of the river was therefore not essential. And the third case I'll talk about is the length of time the tribe has occupied the area. In Yankton Sioux tribe v. South Dakota, the federal district court had found that Lake Andes was navigable and that the Yankton Sioux tribe owned the lakebed under treaty entered in 1858. The Eighth Circuit rejected the claim of the Yankton Sioux tribe because the tribe was trying to claim aboriginal title. they were unable to prove exclusive occupancy dating back to before the Louisiana Purchase. In the record, they established exclusive occupancy of the lands around Lake Andes as of 1810, but the Louisiana Purchase occurred in 1803. The tribe in this case did not attempt to argue that the United States had purposely divested itself of the navigable water. So it's unclear whether the tribe may have been more successful had that been the argument made. There are two additional cases that might provide some help in answering these questions. United States v. Alaska, where the court determines that submerged lands near the petroleum reserve are part of the National Petroleum Reserve and therefore owned by the United States. The important factor here seemed to be the purpose element. So by executive order of 1923, the president had reserved the National Petroleum Reserve to maintain sufficient petroleum for future military needs. The court found that that purpose would be frustrated if the state of Alaska was the owner of submerged lands adjacent to the reserve. And again, in Utah Division of State Lands v. United States, the court seemed to focus on the purpose. Here, the Sundry Appropriations Act of 1888 had called on officials to select sites for reservoirs and other hydraulic works for irrigation or flood control. An official had selected Utah Lake as such a site. 2 years later, that act was repealed, but in the repeal it noted any lands that had already been selected would continue to be set apart and there would be no settlement. The court found that the purpose, a future reservoir for hydraulic work, was not going to be frustrated and said that Utah was the owner of Utah Lake. As one last visual, also available through the Oil and Gas Division's website, GIS Map Server, another shot of the rig locations and then a general sense of the river, and you can still see where the reservation is located on that one too. Both the North Dakota Department of Trust Lands and the three affiliated tribes are leasing mineral interests underlying the bed of the Missouri River. The leasing by the state appears to be limited to the location of the river near the time of the flooding of these tracts. 31 wells have been spud and are producing on spacing units that include portions of the Missouri River within the reservation. As of March 7th, no negotiations between the North Dakota Department of Trust Lands and the three affiliated tribes are ongoing, and we are not aware of any litigation that's been initiated to resolve the dispute. Based on the maps that are available through the NDIC, companies are continuing to develop spacing units that include riverbed tracts, and it seems like it'll be a really long time before all of these questions are answered. I have tried to provide a really broad overview of some really complicated tribal topics and federal Indian law topics, and I'm happy to suggest additional resources if anyone's interested in learning more. Recognizing that we are the last speaker on the agenda today, we would be happy to answer anyone's questions if you want to come up and talk to us after closing remarks. On behalf of Tim and David, thank you all for your attention.